This event is a big deal, and I'm very honored to be here and to welcome you all to the I. Goodman Cohen Lecture in Trial Advocacy. So this lecture was established by a generous gift of the family of the late I. Goodman Cohen. Mr. Cohen was a prominent trial lawyer. He was active in the Michigan Trial Lawyers Association, which is known today as the Michigan Association for Justice. And since its creation, this event really has become a staple of Wayne law. And we owe that success overwhelmingly to Dennis and Ina Cohen, who year after year work very hard to make sure that this event, paying tribute to their late father, is one of the highlights of our year. Ina is a 1974 graduate of Wayne Law School. She's also a member of our Board of Visitors. And Dennis flew in from California just to be here today. So Dennis, thanks for making the trip. We're indebted to their hard work and their generosity, and we're very happy to have them both here. So please join me in thanking them for their support of this program. I know we've got numerous moot court and mock trial students in the audience here today. Thanks to the support of people like Ina and Dennis and our faculty and our staff, and especially thanks to your own hard work, you've had a lot of great successes lately. You know, our moot court team is, I think, ranked 17th nationally. That's pretty cool, in my opinion. And so we're proud of you. And we're very happy to have you here today because this event is of particular significance to you. Today you're going to hear from a couple of giants in the trial advocacy world. You're going to get a glimpse of the kind of trajectory you can have and the kind of difference and impact you can make. Michael Pitt and Dana Nessel both have been instrumental in cases that have really changed the fabric of our communities, and I don't say that lightly. They've fought on behalf of same-sex marriage to give same-sex couples the same civil rights we all enjoy. They fought on behalf of female prisoners who have been raped and sexually assaulted by prison guards. These are serious topics. They embody the sort of ethical and public-facing norms and behaviors that we all should aspire to as trial lawyers. And so we're very, very privileged to have them here. I know Professor Schenk is going to say a little bit about each one of them, so I'll just keep my remarks brief. But Michael Pitt was in the same class as Ina Cohen here at Wayne Law, a graduate, 1974 graduate of the law school. He also serves on our Board of Visitors. And he and his wife, Peggy, throughout the years have been great supporters of the law school, including through scholarships, and so we're deeply appreciative of that. Thank you, Michael. Dana Nessel, also one of our graduates, a graduate of the class of 1994, and really someone who's been out there leading by example and showing the kind of impact you can have with your Wayne Law degree. She was named Woman of the Year by the Michigan Lawyers Weekly. She was recently honored at the Treasure of Detroit Gala for her outstanding contributions to the legal community in Michigan. And we're so happy to have you here, Dana. Thank you both for being here. I'm now going to hand this over to distinguished Professor Alan Schenk, who's going to moderate today's discussion. Alan, thank you.
Thanks, Rick. It's a pleasure for me to be here today for an I. Goodman Cohen lecture. I knew Ina and Dennis's parents for many years. But I'd like you to indulge me for 1 minute, and that is to say something about my colleague, Larry Mann, one of the great students of this law school. He graduated in 1980. He made such a mark. I remember the seat he sat in my class. He claims he's retiring at the end of 2017. What a great loss. Larry has not only taught our students, especially products liability over the years, but has helped our faculty develop an excellent program for students interested in litigation. And in the past few years, he has strengthened our trial advocacy program and assisted students that are competing in national moot court programs immeasurably. He's helped create a welcoming environment at the law school for our students of color. Larry, thank you. He doesn't like praise. So the dean said a few words about Dana Nessel and about Michael Pitt. He took some of my words, but Dana, after law school, worked as an assistant Wayne County prosecutor for over 10 years. Work in child and family abuse, shaken baby syndrome, parts of the police conduct review team that investigated and prosecuted police shootings of civilians, part of the auto theft unit, and in 2014 she left to establish her own law firm, Nessel and Kessel today, defending indigent defendants, civil rights actions against police departments and government agencies, obtaining personal protective orders against abusers in domestic violence cases. She litigates LGBTQ issues, including a case that we're not going to talk about today, but significant, the Harmon versus Davis case that obtained custodial rights for a non-biological parent in a same-sex couple. She's defended people wrongly targeted for prosecution because of their sexual orientation and gender identity. And more recently, she established with our Wayne County prosecutor, Kim Worthy, the Fair Michigan Justice Project, investigating and prosecuting crimes against members of the LGBTQ community. She's received many awards. The dean mentioned some. She received the Champion of Justice Award from the State Bar. Actually, Michael received the same award from the State Bar. We are indeed honored to have both of them today. And in 2012, she got involved in the DeBeer case that was consolidated, went up to the Supreme Court, where the Supreme Court in Obergefell legalized same-sex marriage nationwide. DeBeer versus Snyder is a law school filed by a same-sex couple in 2012 in federal district court, initially challenging the ban on joint adoption by unmarried same-sex couples. And then, and we'll hear more about this, they amended their suit to challenge the 2004 constitutional amendment, the Michigan Marriage Amendment, barring same-sex marriage. Michael Pitt started practice in the area of employment law, workman's comp, other labor matters, and then established his own firm with his wife, Peggy Pitt, who's here today, the Pitt, McGee, Palmer, and Rivers firm. His practice concentrates on single plaintiff cases in employment law, in civil rights, in criminal defense. But he has also litigated nationwide class actions, group actions, multi-party cases on behalf of employees. He's been appointed mediator. He's involved in actually, in the Flint water crisis cases. He was president of the Michigan Trial Lawyers Association, president-elect of Public Justice. Public Justice happens to be the largest public interest law firm in the country. He promotes rights of disabled persons. He established a scholarship here at the law school for a disabled student, and has not only provided, he and Peggy not only provided that scholarship, but they follow up with disabled persons, and he helped one become a member of the bar. So Michael, this case is a little different. Michael entered the Neal case after it was ongoing for years. It was against the Michigan Department of Corrections, claiming that women prisoners were subjected to a pattern of sexual misconduct, sexual harassment, and abuse by the Department of Correction staff at the Scott Correctional Facility and other prisons. And this case was to address and reform the treatment of women prisoners. So with that as a background, one thing that interests me is, how did you get involved in these cases? How does a lawyer, Dana, that defends indigent people who are accused of crime, and some other cases like getting protective orders against abusers, how did you get involved in this case?
Well, previous to the DeBoer case, which we brought in 2012, I had already started to get more involved in defending actions that involve the LGBTQ community. And really that began very unintentionally for me. It was more because there was really a dearth of attorneys that were willing to handle these cases. And the biggest reason for that is that we didn't have, and still continue not to have, protections for the community. So there were a lot of attorneys that were not interested in sort of making new law because there wasn't any law that existed at all. And so when I began to get involved in these actions, literally no protections of any kind, either federally or under state law, and that involved everything. It involved employment and housing, adoption, marriage, all the rest of it. Most of that is still true today. But what began to happen, honestly, is that I would have people come to me with various issues, people from the LGBTQ community, and they would routinely say the same thing to me over and over again, which was that they had tried to get assistance from various groups or organizations, LGBT orgs or civil rights organizations, and they were generally told that they were out of luck. There were no protections that existed. They weren't willing to sort of go out on a limb and try to do what they could for these folks. And I think a big part of it for me is that, you know, I've identified as a lesbian, as a gay person for almost since the time going back to law school. And I would hear these stories, and I knew that these were not just the stories of people that were coming to me. This was my story too. These were all things that either had happened to me personally or could have happened to me, or one day might happen to me. And I felt this going into law school. I certainly felt this sitting here at Wayne State University Law School, specifically sitting in Bob Settler's classes, of which I took both Con Law 1 and Con Law 2, that we really had an obligation. You know, if you had a P number, if you had a bar card, then it meant that you had some sort of obligation to step in when you saw injustices being done. And maybe you weren't going to win those cases. And there were a lot of cases I didn't win, by the way. But that better to fight, and maybe bring some attention to the issue. Even in a loss, you could educate people as to what the law really was and how it harmed people. And so when I would have people come to me and ask me to take up a case, and I frequently would go around and try to ask other lawyers that I thought had better expertise in these particular issues if they would assist me. Sometimes they did, sometimes they didn't. But I generally always took the cases just because I really felt like someone had to. So that's how I got involved in taking those types of cases. The DeBoer case was not my first LGBTQ rights case. It was after I had handled multiple cases like that.
So, Michael, after representing fired employees and employment law, and the Neal case going on for years, how did you get involved?
Before I answer that question, I want to make a few comments about my friend Ina and her family. I was a classmate of Ina's in law school in 1974. We were also classmates in elementary school. We go back to the good old days in Northwest Detroit in the 60s. And I was a guest at the home of Mr. and Mrs. Cohen, Pauline Cohen, a wonderful woman, Ina and Dennis's mother, and Mr. Cohen, and I always knew him as Mr. Cohen. And as I graduated law school back in the mid-70s, and I took on my first position with a law firm, I would spend most of my Fridays in Wayne County Circuit Court handling miscellaneous motions. And Wayne County Courthouse at that time was a very busy place. And Mr. Cohen...
Still is.
Still is. And Mr. Cohen was a regular in that courthouse. His nickname was Chicky. I'm not quite sure how he got that name, but everybody referred to Mr. Cohen, his peers referred to him as Chicky. Us youngsters referred to him as Mr. Cohen, of course. He would walk into the courtroom on a Friday. He always had an important, serious case, a medical malpractice death case, or a construction site case where the worker was paralyzed. A big case, important case. And when Mr. Cohen's case got called, everyone stopped what they were doing and watched Mr. Cohen. Mr. Cohen was very short in stature, but he was very commanding in his presence. He was an impeccable dresser, I remember. Always had a little handkerchief in his pocket, and had a very commanding voice. And he really was a giant in the personal injury field, and I feel very honored to be here, and I feel associated with him after all these years. I wasn't quite sure when Mr. Cohen had passed away. It was 1978, and he was 68 years old, which ironically is my age. So here we are, another generation, and I do always admired Mr. Cohen, and I'm really very honored to be here. To answer your question about the Neal case, the ACLU called me around 2000 to represent Teresa Cox, who was in the Livingston County Jail, and she was not permitted to have work release. And upon investigation, we determined that the sheriff of Livingston County gave work release to the men, but not the women. Seemed like a pretty outrageous violation of constitutional rights. ACLU suggested that I call Deborah LaBelle, who was notable even at that time as a prison litigator. Peggy and I called Deb. We met. We joined forces. We successfully prosecuted the Cox case, got a great result. They abandoned that awful policy. They actually built another part of the jail as part of the consent judgment. We got tremendous relief in that case. We also discovered that the male guards were violating the privacy rights of the women, to say the least, when they were taking showers and whatnot. And so that all stopped. And then at that time, the Neal case, as Professor Schenk indicated, was up in the Court of Appeals in the Supreme Court. And it just started to come down, I think, around 2002, 2003. And the case was ready for litigation. And Deb asked me and Peggy and my firm to join that case. And so we started a partnership with Deb LaBelle in the Neal case that went all the way through, I think we finished it in 2009 or 10. I've lost track of it. But 2 trials. Each trial was about a month long. We represented in each of those trials about 15 women. It was tried in Washington County Circuit Court. The jurors were very receptive to the cases, awarded multi-million-dollar verdicts to these 15 women. The state didn't believe it happened the first time. They thought it was a fluke. So we had to do it a second time. And we proved to them that it was not a fluke. And they didn't. And we had about 500 more women behind these 15 to go. And so I think they realized that the jig was up and they had to deal with it in a responsible way. And so they ended up changing the policy so that today the male guards, male corrections officers do not supervise women in their residential units. That's the law of Michigan now. That's all changed. And the state paid the women and the attorneys $100 million. There was it was an earthquake process that the litigation brought. So, this is an example of what impact litigation can do. Sometimes it's earth-shattering, like the Neal case outcome. More often than not, it's a small firecracker, a small boom. But even the small booms, when you add them all together, accumulate them, things change. Sometimes it takes a lot of small booms to make the big boom, and that's what we do as trial litigators in civil rights matters.
So the Deborah LaBelle that you mentioned is also a graduate of this law school, class of 1979. You can't go anywhere in Michigan and avoid the Wayne State University graduates. And by the way, she said that Michael was added to the team because she wanted somebody to help with trial tactics. These are 2 very good trial lawyers.
If I can make a remark about that. So, as you mentioned, I was at the Wayne County Prosecutor's Office for about 11 years. And something interesting that I saw develop over the course of the time I was there, I always referred to Wayne State Law as the Harvard of Detroit. But what I began to see happen over the course of years there is that, it was always considered to be a real coup if you scored a Harvard Law graduate at your place of employment. But they actually stopped taking Harvard and other Ivy League school graduates because they found that they were actually not great litigators. And I hate to say that. I don't mean to make such a sweeping and broad statement, but the litigators that came out of Wayne State actually were just much more successful. And the office became gun shy after a while about hiring people from the Ivy Leagues. For whatever reason, the training at this law school really lent itself to being, ferocious advocates in the courtroom. And you would see, you know, of our top trial attorneys in the office, they were mostly Wayne State grads. And I am not trying to say that to belittle people who go to the Ivy Leagues. It was just factually accurate to say that the best litigators came from this law school.
You're preaching to the converted. So I'd like to know something about strategy, the strategy that you utilized in these cases. I know, Dana, that the case started as an adoption case, not as a equal protection marriage case. What was your strategy?
Well, partially it was just to throw anything at the wall and see what stuck. I guess I would say, you know, when you have a situation where you see, I always call it the parade of horribles, just situation after situation after situation where you had same-sex couples, tens of thousands of them in our state, who were raising children together, often because the state had actually given these couples, many of whom were foster care parents, these children to raise. And that was the case, by the way, with, of course, April DeBoer and Jane Rouse, in our case, DeBoer v. Snyder. I was perpetually seeing awful things result from the fact that only one person in that couple was able to actually have legal rights to the children. And the second parent was considered to be a legal stranger. So having seen the various nightmares that unfolded from that, and having brought a case in state court, and actually Justice Kelly was a dissenting voice in the Supreme Court on that case. That was the Harmon v. Davis case you spoke of. I wish I could say that we won that case. We won in circuit court. Thank you, Judge Kathleen McCarthy of the Third Circuit Court. But we were quickly overturned by the Court of Appeals, and that was sustained by the Michigan Supreme Court. But, you know, these were cases, and that was a case where you had a same-sex couple that had raised 3 children together since their birth. And then when the couple split up, one of the parents was the biological parent and had all the rights. The other parent had no rights at all whatsoever. And that particular case, you know, all these years later, we filed it, I believe, in 2009 or 2010, because there was also a PPO case. Renee Harmon has never seen her children ever again since that time. So anyway, it became very clear to me that absolutely, given the state of the appellate courts in Michigan, which are not very LGBTQ friendly, I will say, and predominantly at this time, you know, Republican appointees on both the Court of Appeals and the Michigan Supreme Court. It was very clear to me that a case had to be brought in federal court and not in state court, and where the judges were lifetime appointees, and we would not have to worry about them being up for a re-election or how either the Republican or Democratic Party felt about their decisions. They were free to make whatever decisions they wanted to make. So we knew we had to bring a case in federal court for certain. But when I met April and Jane in 2011, spring of 2011, I believe it was, you know, they just seemed like the perfect couple to bring a case. They were nurses. Everybody loves nurses. And they were raising, you know, their foster care parents raising these special needs children, all of whom had been either surrendered or abandoned at birth. They were specifically asked to raise these children by the state of Michigan, by the Department of Health and Human Services, and in part because they had really special qualifications to raise special needs kids. That's what they did for a living at work. But so we, you know, myself and at the time my co-counsel, Carol Stanier, decided that we would bring this case in federal court. But we were told by a variety of entities that that was a bad idea and that we would be summarily kicked out of court on some sort of obscure abstention-related motions that could be made by the state. So it was at that time that I said to Carol, boy, it would be really nice if we knew somebody who was a really good constitutional law professor who could help clarify this for us, because we both believed that we would be successful, but we had never encountered that sort of issue before. So we thought we'd go to somebody who perhaps knew more about it, and that's when we went to go see Bob Sedler, who, again, had been my con law professor, and I called him up and I told him what our issue was. He was happy to immediately see me. And when I arrived at his office, he had pulled out some law review articles that he had actually authored on this very subject, on the issue of adoptions for same-sex couples, and said to me, you must have read this article, and that's why you're coming to see me. And I said, no, you're really like the only con law professor that I know. I was in your class like 20 years ago. And unlike, as you, Alan, have said about Larry, he did not remember where I sat, nor that I had even attended his classes. And I had idolized him for many years, but he certainly did not remember me. But nevertheless, he indicated immediately that he thought we were correct. He thought that we would be successful, and he urged us to move forward on the case. And he, in fact, I think at that very moment, Bob immediately stood up and started rifling off what would become our first complaints on the adoption issue. Paragraph number 1, paragraph number 2, and then Carol and I just furiously wrote down everything that he said. We obviously started this as an adoption case, not ever anticipating it would turn into a marriage case. But I will say that I said at the time, I think this is a case that's going to go to the United States Supreme Court. Everyone said I was crazy, but ultimately it did, and obviously it was amended along the way and all the rest of it. But that's really how the case started. I wish I could say that we had a very specific strategy, but our only strategy really was to challenge the Michigan Adoption Code for the many reasons that we thought it didn't even meet the lowest levels of scrutiny from a constitutional perspective.
So, Michael, I've read something about the Neal case, and one thing that impressed me about the strategy of that case is that your strategy in part was to empower the prisoners. So can you tell us something about that and other strategy that you had in this case?
Sure. So one of the defense arguments that we faced as we approached trial was their doubt, the state's doubt, that a average juror would award large amounts of money to women who were incarcerated for serious crimes. Some of our clients were in for life, for murder. I mean, we're talking about the most serious of serious crimes that these women were in prison for. So, we wanted to understand if that was a real concern or not. So we arranged for a mock trial. And in the mock trial, we learned 3 things. One, we had video of some of the women and their stories, and so it was very emotional, and the jurors could get a true sense of what the actual jurors are going to experience in the courtroom. So we played some of these videos for them, and then we told the jurors what the crimes were for each of these women. And when they deliberated in their mock jury room, they came back with substantial awards, and we were able to interview them to determine whether the crimes were relevant. Not a single one felt that the crime was a factor. The violations that we laid out were so overwhelming and so important to the jurors that they realized that this was not part of the sentence. They weren't sentenced to be raped and to be sexually harassed. So we were obviously very encouraged by that result. The second thing we wanted to know was, should we pursue claims against the individual correction officers or should we just focus our case on the department? We found from the mock jury that the claims against the individual officers was a big distraction. The jurors couldn't sort out who was responsible and what they should do. And as a result of that, we decided, with some, trepidation, to dismiss all the individual officers before he went to the jury. And the jury just heard the case against the department. Now, under Michigan law, if the department is aware of a sexually hostile prison environment and failed to take appropriate remedial action, they are liable for their own negligence, for their own misconduct. You don't need to prove vicarious or respondeat superior liability. And so we dismissed, on the day of trial, we dismissed the claims against all of the individual officers and just went against the department. The AG went nuts, but we were successful in that endeavor. Those were really the two main things that we learned in the mock trial, and that really gave us a lot of confidence. I can't tell you how important, if you try cases, how important it is to have a level of confidence in your case. That gives you the energy to keep going and keep going and keep going, even while it can be a very difficult physical task. You need to find energy. And having confidence in your case gives you that energy to keep going.
Thank you. So in both of these cases, other lawyers, other organizations were involved. And I wonder, how does that happen? And, I think of myself, well, it's my case. I want to do it. I want to get the credit. I want to get the fee. So what was it? Cost, experience, length of trial? So Michael, let me start with you.
Yeah. So, doing high impact litigation, where the outcome of the case could have significant effects on small groups of people, large groups of people, even the country at times. Dana's case is a perfect example of that. Her effort led to a nationwide change, so we had marriage equality for everybody. That's as high as you can get in terms of impact. It requires a team and different talent categories. So I have members of my firm here, high members of my firm. Megan's here, and Jennifer and Robin are here. And doing a great job for the client means collaborating with talented people. And sometimes you got to go outside your own firm to bring in that level of talent that you need to win the case. Professor mentioned that we're involved in the Flint water crisis. Well, the talent team on the plaintiff side is just unbelievable. We got attorneys from New York and from Washington, D.C. and from Florida. We got many lawyers from right here in the Michigan area. And there are many different categories of talent, and it all kind of comes together like a grand symphony. Everybody that's experienced on the team does what they're supposed to do, and it comes together. I think Dana would probably agree that she had a great team of lawyers that she worked with, and they divided up the work, and things happen. And if you're going to do this kind of work, you're not going to worry about the fee. I think Dana and I would, and many of the experienced civil rights attorneys here would agree, if you do good work, the fee will follow. You don't take cases to earn the fee. You take cases to do the good work and to accomplish what you want to accomplish for your client. and then, God willing, the fee will come.
How do you determine who's going to litigate the case? Who's going to be the trial lawyer?
Sit around a table and you talk it through and you decide. I mean, it's like anything else in life. You just work it through. And, you know, we've always been involved with lawyers with what I call manageable egos, so that, you know, to be a good trial lawyer, you got to have a healthy ego, but it can't be out of control. I mean, you've got to be able to work in a collaborative team environment. And if, you know, if one person's ego is out of control, I would tend not to associate with that person, because it's not going to work. And if it does work, it's going to be very rocky and very unpleasant. So you try to avoid that if you can.
Dana, what about your team?
I wish I had a really nice story of how well coordinated this all was. But my experiences in my, I guess almost 25 years of litigating cases now, is I've never once had a trial, and I've had hundreds of cases go to trial. I've never once had a case go the way that we planned it, ever. Things always happen. Nothing ever goes exactly the way you plan it. And part of being a good litigator is having the ability to either anticipate the things that may go wrong, or to be able to immediately deal with those things in the best way possible, given the circumstances. But, you know, our case, you know, when we was back and forth when you talk about organizations, when you talk about other attorneys, you know, when this case was initially brought, it was just myself and Carol Stanier who had kindly agreed to work on this with me. I was smart enough. I think the best thing that you can do is to know the things that you're good at and the things that you're not. Everybody has their area of expertise. You can't be an expert at everything. And I had a lengthy background as a state trial court attorney, but I did not have a lot of federal appellate experience, but Carol did. And that's why I enlisted her initially, and then we moved forward with Bob after he volunteered, and we brought in another attorney named Ken Mogul, who was very helpful as well. But as time went on, you know, initially we didn't have any organizations that wanted to work on this case, and they urged us not to bring it because they thought we would set bad precedent. And my feeling at the time was that, and I think the theory that a lot of the organizations were utilizing is that if we were going to make progress, it would never be through the Sixth Circuit. It would only be through the First Circuit or the Second or the Ninth, or more open-minded liberal districts than we had here in the Sixth, which is for a very long time deemed to be one of the most conservative circuits and one of the most overruled circuits in the nation. But, you know, my feeling personally was that, you know, the people in Michigan were suffering just as bad as people in other states. And it seemed to be taking a really long time for the progress that was happening in other states to affect us here in Michigan. We were one of only a handful of states in the entire nation where we didn't have any mechanism to provide rights to both parties in a same-sex couple. So when we first moved forward on the case, it was just us local Detroit attorneys. As the case gained momentum, and as we had Judge Friedman, who urged us to amend to a marriage case. When I say urged, I really mean he forced us to amend. It was clear that our case was going to be dismissed if we did not do that. But as that happened, as there was success nationally on the Windsor case, which was the Defense of Marriage Act in 2013, as momentum seemed to be building in favor of the petitioners on these sorts of cases, then those organizations did want to become involved because I think they saw the writing on the wall that, you know, these cases were going to ultimately be successful, and now they wanted to be a part of it. And, you know, there were obviously some attorneys that, you know, when this is all you do all day, every day, you're going to have more expertise sometimes than sole practitioners who do a lot of different things, but are just taking on this case because they feel like somebody had to. So we did have we had members of other organizations that would come in and that would advise us, or that would participate in our case, even though it was still being directed by the local attorneys. I think there was a lot of fear, frankly, as the case was scheduled for trial. And again, we were only to be the third time ever in the history of the United States that the issue of marriage equality was to be put to a trial. There was a lot of fear that the local attorneys, would sort of screw this up for the entirety of the United States because this trial had become so important. And we were constantly getting advice from outside organizations and people who wanted to come in. And I will tell you that the attorneys on the Proposition 8 case called us to see if they could take the case over from us. And at that time, we had worked on the case so arduously for so long, there was no way we were giving up the case. But also, our clients wouldn't allow it. I mean, the clients, even though you're potentially setting a national precedent, they still have some say. And they weren't going to just have some people fly in from California and take over our Michigan case. Not to mention the fact that our judge had personal relationships with all of the local attorneys, which we thought was only helpful to our case. And I know that Judge Friedman respected the attorneys on the case. But that being said, as the case moved forward, and now we're past the Sixth Circuit, we've lost at the Sixth Circuit, and the cases have been consolidated with the Ohio and Tennessee and Kentucky cases, and we're at the Supreme Court. The Supreme Court absolutely refused to divvy up the arguments. And believe you me, every single lawyer wanted to argue before the United States Supreme Court on the case that we knew was going to be the seminal case on marriage equality. And so we had, I don't even know how to explain it, and I think it's now been written in history books, so I can disclose things that were to be confidential since they're already written about. But, you know, we had all the attorneys from all 4 states, and now we had organizations that now had joined in on every single state case when they had not been there before. And we all had it out at the University of Michigan Law School. You know, there were dozens and dozens of attorneys by this time between the 4 states, all of us screaming and yelling at each other as to who would be the best person to argue this case before the United States Supreme Court. And it was a nightmare. I mean, there's really no other way to put it. You talk about there being egos, but who didn't want to argue this case, right? We finally came to a settlement, and we all decided mutually that Mary Bonauto would argue it. Mary had signed on now to be an attorney on our case, on the DeBoer case. And she had been very helpful to us in terms of advising us during previous junctures of the case, including at the trial phase. She did not actually try it, but she was assisting us. I know Bob worked with her very closely on a few different issues on the case. And she had brought the Goodrich case in 2003, which was the case that allowed for marriage equality in the very first state in the nation of Massachusetts. So we thought it was fitting to have her argue what we hoped would be the last case on marriage equality. But for me personally and for the people on our team, we thought it was very important because the other states had wanted to bring in straight white men to argue the case. And we felt as though it was very, very important since most of the petitioners on the case were women. We thought it presented poorly to say that it was, you know, to have mostly women and mostly lesbians be not just the petitioners on the case, but also be the attorneys to then say that at the very end we needed this to be argued by a straight man, that it presented very poorly. And we, you know, it was very important to me and to Carol and to April and to Jane and to a lot of us that we have a woman argue the case and that she be a gay woman. And
so can you tell us who Mary Bonauto is?
She is an attorney from GLAAD, the Gay and Lesbian Advocates and Defenders. She was actually out of Maine, and I think she worked out of their Boston offices. And so she had been an attorney who had been working for very many years on these issues, very well respected. But, you know, to say that we weren't hopeful that somebody from the Michigan team, our local Michigan team, would argue it, I would be disingenuous if I told you that. There were a lot of arguments prior to figuring out who would do the argument. And it was that day at the law school, and I remember it because it was my kid's birthday. And as, you know, when you get involved in cases like this, unfortunately you end up missing your kid's birthday party sometimes, right? But I mean, it was a ferocious argument. I've never seen anything like it before. I hope to never participate in anything like it again. Ultimately, I feel as though it probably didn't matter who argued the case, because I still can't believe to this day that those 9 justices didn't absolutely know what they were going to do before this case was even, before they even accepted cert on our case. They knew what they were going to do. I don't think that Justice Kennedy was swayed one way or the other by either our arguments or even the pleadings in the case. I think he absolutely knew what he was going to do. But for the purposes of history, the same way that on, Brown v. Board of Education, no one said to Thurgood Marshall, hey, you've done a great job up until now, but let's find some white guy to argue this case on behalf of black school children in this country. We felt it was important to have a woman and to have a gay woman argue it, and that's ultimately what happened, and we were still successful nonetheless. But it was a difficult process, I think, making the sausage, I guess, as you would say, getting to that point.
So what about surprises at the trial level? The one thing that I read about is Judge Friedman. Were you kind of surprised when he said to you, change your pleadings?
Surprised would be the most mild way that you could possibly phrase that. We were shocked / kind of horrified, because we had not intended to bring a marriage equality case at all. I will tell you that we went immediately after Judge Friedman made this indication to us. We all went into this back room in federal court there in the Eastern District in Detroit, and they have these conference rooms, and everyone in the room was crying / terrified / horrified, with the exception of Bob, who said, "This is great." He said, "This is the best thing ever." And I thought he was going to get tackled right then and there. I will just be honest with you. He was delighted. He thought the fact that we were going to get an opportunity to actually take on the issue of marriage equality was tremendous, but we had all shied away from that. We purposely didn't bring a marriage equality case because we knew that that would be overwhelming. And again, we were at a place where all but about 5 states in the entire country had parity when it involved adoption. So we weren't really making new law at that point. And it seemed so obvious. I felt so confident in our ability to win it. And also, I never expected in a million years we'd be trying this issue. I thought everything would be decided on motions for summary. But we were horrified because we knew that at that point it was going to become an incredibly big case, much bigger than we had expected. And frankly, none of us, except for, I guess, Bob, were prepared for that at that point.
So, Michael, one thing that I found very interesting about the Neal case, and I'd be interested in knowing what surprised you, but what surprised me was the jurors after the decision. Can you tell us something about that and what other surprises you had?
So the first surprise that came out of the jury room was, I'd say, about 10 days into the trial. And the jury sent a note to the judge and said, in essence, can you make the defense attorney be a better lawyer? I mean, it went on and on about how bad the defense attorney was, but essentially the message was, the defense attorney is not doing a very good job, and it's bothering us. Can you do something about it? So, that's never happened to me in a case, and when you're put in the situation as the jury's saying to your side, we think you're doing a great job, and we think the other side's doing a terrible job. You got to be careful about not to overplay that hand, right? You got to show some humility, even though the jury is signaling, who they're with. And so that same jury did something even more remarkable at the end of the case. So they, now mind you, we, every day for a month, the women would be hauled into court in shackles. before the jury got in, they would take the shackles off, and there was no, no appearance of being a prisoner in the courtroom. And as soon as the jury left, they would shackle them again and take them away, and they were being housed in the Washtenaw County Jail from day to day. And it was, really wearing on them, because many of them had been at Scott for years and had friends, and their whole life was centered around that environment. And now this was so disruptive, so they were getting really worn down. They were really getting worn down by the whole process. So the jury went out for a day and a half or so, and sent a note to the judge saying, we have a verdict, but we would like to address the plaintiffs as part of the verdict. And I still get choked up thinking about it. It was so wonderful. I mean, the jurors came into the courtroom and had all the women stand up, face the jurors. They apologized. They said, we're so sorry this happened to you, and we're, as citizens of the state of Michigan, we want to apologize to you.
Amazing.
For what happened. And it was, and I've got some videotape. I don't play it very often, but I guess it's, part of my legacy. Someday somebody might play it. But I mean, it was, everyone in the courtroom, including the judge, was in tears. We were all blown away. The jurors sat down, and then, the jurors read these verdicts: $2 million, $3 million, $5 million. I mean, it was, it was just an incredible day, to watch, how justice just comes from, average people on the jury doing their form of justice, what they felt was just and fair under those circumstances. And the saddest thing about that whole day was, the lawyers were celebratory, and we left, and we had to leave our clients back in the lockup, shackled. I mean, it was just the contrast between the lawyers and the clients and the jury and the judge. It was just, your head was spinning for a couple of weeks afterwards. You still couldn't get over it. And then being at Washtenaw County, we had quite an array of people on that jury. I mean, we had PhD scientists from the University of Michigan that were on that jury. And one juror at 3 o'clock in the morning, right after the verdict, sent me an email with probably a 12-page single-space critique of the trial, including me. He said, sometimes you come on too strong. Maybe you ought to back down a little bit. And he had comments about every personality in the courtroom, and commented about the jurors and the judge and the defense attorneys, and the clients, and it was a remarkable critique of what we had been through in a month, and coming from a very credible source, an actual juror who was highly educated and was viewing the world from his lenses. It was just remarkable. The whole experience was like career altering for me.
So I want to leave some time for the audience to ask questions, but I have a couple quick ones. Did you have some particular obstacles that you had to overcome to be the great trial lawyers that you are today? Stage fright, was there something? Michael, if you can remember back over 40 years?
Well, for the students in the in the auditorium, I mean, I had great doubt about what I wanted to do as a law student in my career. Growing up in the 60s, there's a lot of conflict in terms of young people and what they wanted to do. That the old establishment was fading away, the new regime was coming on, and half of me said I want to work for a big silk stocking firm and be Mr. Big Shot lawyer working for a big firm. And my wife is shaking her head. That's not me. That was secret. That was my sort of my secret wish, And then a friend and I in law school decided to join FLAC, and it was over. There wasn't any more doubt about where I wanted to be. I knew I wanted to represent people in the courtroom and deal with their issues, their human issues, the human side of being a lawyer. That's what I wanted to do. And I'm telling you, FLAC did it for me. It completely changed my orientation, and I think for the better. There are a lot of people that I've provided service to over the years who are glad I went to FLAC, because it changed me. And any fears that I had about being an effective advocate, I mean, they vanished. By the time I finished my FLAC experience, I thought I could conquer the world. It was such a confidence builder to go through that experience. And I got to say, back in the 70s when I was in FLAC, it was very loosely managed. I mean, the student lawyers really ran the show there, and we took great liberties with the lack of management. We did some pretty audacious things back in those days, and the judges that we appeared in front of were, they were supposed to have a supervising attorney, but they didn't always require it. So we had a good time.
Dana, any obstacles to becoming a trial lawyer?
I would say that, well, firstly, I think that Wayne Law did an amazing job between, I was in the STAT program, I was in moot court, and I think those were very helpful. But I think for me, what was most helpful was I interned and clerked at the Wayne County Prosecutor's Office. They had an amazing program there, maybe too good, because I actually ended up trying a double homicide as a law school student. Under the court rule 8.120, I believe it is, as long as you have a supervising attorney. But that's what happens when you work in a county where you have some 400 murders in a year. You get a lot of chances to try murder cases. But I know that a lot of my, preparation in terms of all of that came from working in an office where you were understaffed and you had, one of the busiest dockets of any place in the country. And it was not unusual to walk into work and to know that somebody have your boss say, so-and-so called in sick. There is a panel downstairs in courtroom 802, go try this armed robbery case. And they would just hand it to you. And it made me laugh when I would think about how we'd have a whole semester to prepare in the student trial advocacy program for your one case. And here sometimes you'd have not even minutes where you received the file, you went downstairs, and it was not unusual for me to do an opening that consisted of, ladies and gentlemen of the jury, you will hear about an armed robbery that occurred on December 20th, and you just had to wig it and play it by ear, and that's how you tried cases oftentimes. I'm not saying it's the best way, but it was the reality of it. And I think that those are the kinds of things that, make you the kind of a attorney where you just learn to go with the flow, because that's just your practice. And like I said, no matter how hard you think you'll be able to prepare in advance, and I'm not saying you shouldn't try your hardest, sometimes life gets in the way of that for various reasons. So
thank you. So from you in the audience, any questions?
Let me say, I've never been prouder of my association with Wayne's Law School because of you two. Just thank you so much for sharing with us.
Hi, is this working? Hi. You guys talked about as doing, civil rights litigation that you're not following a paycheck. And, you know, I respect that, and I think that is fantastic. I think that is the right way to go. But unfortunately, with the economic reality, so many students, such as myself, coming out of law school who want to be civil litigators are facing, if not six figures of debt, close to it. How do you go about that? And are you concerned that there will be more people going the route, like you said, the big fancy law firms who could maybe make a bigger impact, and just that type of thing? And also, I did black. Black is fantastic.
Any comments?
Yeah, I think that's a huge problem. I think it's a huge problem. When I went to law school, I mean, I don't want to tell you how much cheaper it was than it probably is today, but so much so that, you know, from the Metro Detroit area, I lived at home with my parents. I worked mostly full-time, and I was able to pay for my own law school, and it really wasn't a problem. I mean, it was not that expensive for me to do that. And I know that that's not the case nowadays. So when I started at the prosecutor's office, I was virtually debt-free because it just wasn't that expensive to go here at that time. I mean, and again, I could work with my way through. So I could start off in a place where, yeah, I could make $35,000 a year, which was my starting salary at the prosecutor's office. And it doesn't get a whole lot better from there if you are a public servant. And I could feel like, okay, I wasn't going to make a lot of money, but I wasn't in that kind of debt. So now I do talk to students who say, I want to be able to do what you're doing or what you did, but what do I do? I have an entire mortgage to pay for that's just my student debt loan. It's the same as a mortgage. And I know that, you know, they were initiating some sort of, like, if you worked in some sort of civil service, if you were a public defender or a prosecutor or you know, various other kinds of governmental service, they did have a loan forgiveness program in place that I think now they've started to eradicate. I will say I'm not a fan of the DeVos administration. I think there were a lot of, unlike probably everyone else here who is, there were a lot of good programs they started to put in place that were debt forgiveness programs. And I think the most important thing they can do is to encourage people to go into public service and to do so by forgiving their loans, because it creates a situation where you have your best and your brightest are not able to do the kind of work that I know Mike and I have done over the years because of the incredible burdens of the albatross of your student loans. And I think it's a plague in America today. And unfortunately, when it comes to civil rights work, you can't have only the most wealthy among us be able to litigate those kinds of cases, because it means that you'll have people who don't necessarily understand those issues the same because they came from such, you know, prodigious, you know, wealth. And I hate to see that happen, but do I think it has an impact? Absolutely.
Let me follow up what Dana said. You know, our practice is firm based, and the firm really is a cooperative among all our clients, because most of our cases, I'd say 95% of our cases, are done on contingent fee arrangements. And so that means that in a firm of my size, we have like 9 lawyers. Every client is a bit of a partner with us, because some of the work that we do is going to generate, you know, very large fees, and then some of the work we do is going to generate very small fees or no fees at all, and everyone gets the service, and the clients with the really blockbuster cases help fund the operation, so that the people with lower end cases, people who need some justice but can't afford it, and maybe there's not much of a reward, they can get legal services. They can get quality legal services. So there are many, and Michigan has a very strong tradition of encouraging lawyers to proceed with cases on a contingent fee basis. There's been efforts to put caps and things on it, but so far it hasn't really worked, because I think the establishment, the judicial officers, people who make the rules, understand that contingent fee contracts are essential in our democracy. You cannot have an independent judiciary without independent lawyers, and independent lawyers have to be able to proceed with cases, and the contingent fee way is the way to go. So if you can hook up with a contingent fee firm and sort of find your way, sometimes you can prosper in that environment. I know it's all changed now since I started, but it's still an open possibility.
Let me say, I'm doing the history of Wayne State University Law School, and I am proud of the fact that starting with a student that graduated in the first class in 1928, we have a history of civil rights lawyers that have continued for the past 90 years. It's quite a tribute to this law school. So I think our time is up. Michael Pitt, Dana Nessel. I always do that because of the name of your firm.
That's the second time that's happened to me in the last day, so I'm used to it.
Thank you
very much. It's the risk you take when you partner with somebody whose last name rhymes with yours.
Right. So Dana Nessel and Michael Pitt, thank you very much.